So the committee understands that Guatemala has strong feelings that it would like to address question 10, I believe it would be, and provide an answer through one of Guatemala's, I don't know if it would be the Procurador General del Estado or would be someone else from Guatemala's team who'd like to answer. They feel strongly that we should take this opportunity now that we have them here and they made the effort of coming over to the hearing to hear them on this point. And the committee feels sympathetic and understands that need and that wish. This is a very important point to both parties. Guatemala's knowledge or deemed knowledge of circumstances which might have been given rise to doubts as to the impartiality, question the impartiality and independence of Mr. Alexandrov. I'm sure TECO has strong views too on when Guatemala was supposed to have known. So we will give the opportunity to TECO to also address this point. And given that we've got officials from TECO here, perhaps they wish to address the committee too and say something about how they feel about this case. We're happy to hear them too. And now that we've got the opportunity to hear them, if they feel comfortable doing it, of course, in order to provide the same opportunity to both parties.
And Madam President,
yes,
the distinction is, again, we don't have an issue with who addresses the committee.
I know.
Right,
And this is just the beginning.
Okay.
Let me just finish, of course. But, and there comes a bit, but. The but is that we don't want to hear witness testimony. We have heard Guatemala. Guatemala says, and it's an allegation, it's an argument that has not been supported with direct witness evidence, that they did not know and that they only learned once the resubmission proceedings, at least they were closed. I don't know whether the award was issued or whatever. That's a bit blurry in my memory, but I think they said that they could not have raised it at any significant point during the resubmission proceedings. And that is an allegation not supported by evidence. And we do not want to hear witness evidence on that point. This is not the proper time to do that. So if anything during the answers to this question starts resembling anything close to witness testimony, I'm sure Ms. Medaka, please object and we will cut it there. Is that understood?
It is understood. I just discussed it with the Attorney General. I will respond very specifically on the date or approximate dates, and that's it.
Again, if they are repeating an allegation that they did not know at the time of the proceeding, that is what they have alleged. That is fine. Responding with a date when they learned of something or their knowledge, that is where I believe it crosses the line.
Well, if you allowed me.
Yes.
So if that is the situation, then I would suggest that the annulment committee clarifies how we should respond to the question, because it seems to me that the question is very specific. And I don't see the way around than providing a date for that. And I'm not alleging anything. And I can also say that this can be corroborated with a document if it's necessary. And if the opinion, my opinion, or what I'm going to say, no opinion, is challenged. I mean, we have nothing to hide. There's a specific question from the annulment committee, and we request the opportunity to respond it. Otherwise, we are in the hands of the annulment committee. You instruct us how to respond it. And
so you have a specific answer, a specific date or range of dates in which Guatemala came to know of the routinely faced challenges of Mr. Alexandrov. Is
Yes.
that your proposition?
That is new evidence.
Absolutely.
We're talking about, I mean, documentary evidence. We cannot possibly have the admission of such evidence at first in an annulment hearing, certainly not at the hearing and the last day of the hearing. I mean, we would have in that case the ability to call witnesses, just cross-examine the witness, to ask for document production. That's not what this is. It's just not the proper forum for that. And I would say with respect to question 10, we were going to raise it when we got to that, is that we did have an issue with that question, only one clause in it. Of course, when you say Dr. Alexandrov routinely faced challenges, the second sentence, fine with us. When are they deemed to have obtained knowledge? That is a legal issue. But that first clause, after the bracket, when did Guatemala first come to know of this? That is what I was anticipating raising with you when we got to that question, that we had problems with that aspect of the question.
Let's turn the question around. Let's start by the second part. When does TECO think that Guatemala was deemed to have obtained knowledge of the routinely faced challenges? And then we will hear Guatemala explain to us, without introducing new evidence, why it thinks that on those dates it did not obtain knowledge. Okay? No new evidence.
Well, I don't know. I have to hear. I don't know how to respond that I don't know, that I know something that I don't know, or that
Well,
my
you can say
client.
simply, we did not know. Okay?
Okay. Let's see.
Let's hear then, Ms. Menaker, on when exactly it should have known of these challenges.
Sure. And
The second part of the question talks about deemed knowledge. That is what the president is asking TECO to deal with. Your argument in response is intended to deal with when you say you should be deemed to have had knowledge or not.
Well, that is a very different question than the one that is addressed in the questions that we received yesterday. And if that is the question, I will not answer that today. That requires more work on our side. I mean, the question is substantially different, the one that it has been put to us. It's not the deemed knowledge that is claimant's position. We have a different position when is the real date that Guatemala got knowledge of the situation.
The first sentence frames the second part of the question. The issue of Guatemala's deemed knowledge. That is all that question deals with. If you want us to amend the question, we're happy to do so. If there's misunderstanding from that first sentence is not the question. The question is in the second sentence.
The question is framed in a way to allow you to identify for us where in the record, where in the evidence shows when you know or when you did not know. If you don't, then the deeming will kick in And then you have to answer the second part of the question.
We think that who has to prove the date in which Guatemala got knowledge of this situation is claimant. So if claimants doesn't want to demonstrate that and they would like us to not to respond that, we are not going to respond that, but we should not be
Let's hear,
kind of
let's hear TECO on the
shifting
second
the burden
question.
of proof. I mean, I think that we're shifting the burden of proof and we are not prepared to do that here.
We've already heard the parties on who has the burden of proof, whether this is a requirement or defense. We've already heard the parties on that point. So, Ms. Menaka, please.
So thank you. And I won't repeat that, but obviously disagree with, obviously we don't have the burden to prove when Guatemala had knowledge. They have to bring something promptly. So this all as to when they should be deemed to have had knowledges of these challenges, it's as soon as that information was publicly reported, which was very close in time to when those challenges were brought. And we have that evidence in the record and we will compile it for you. But in particular, you might recall when Ms. Young was arguing yesterday, or I think it was yesterday, on slide 11, she showed that other states brought challenges when, and it was in direct response to other disqualifications proposals being made, which showed that these things were reported in the press quickly. And for instance, in Burlington versus Ecuador, and we put this on the screen for your convenience, you have Burlington versus Ecuador, and there.
But that case is irrelevant. It's not about this case. I mean, when is that happened? I mean, I think that the question is very specific. When is that happened in our case?
Mr. Torterola, let Ms. Menaka continue.
Okay.
So the point that you were making is, well, this was public knowledge and other states did use the opportunity that they got this information to challenge, right? Is that what
Precisely.
you're saying? Yes. Good. Then continue. It's an
Precisely.
argument.
So, and the first example was Burlington versus Ecuador, where Ecuador is stating that it became aware of repeat appointments by Professor Vicuña by Freshfields through an article that was published in a newsletter. And excuse me, so this is not about knowledge of a challenge, but it shows that information about what is going on in investor state cases is published in GAR, in IA Reporter, that respondent states that are involved in investor state arbitrations keep abreast of, and they react. So there they were reacting to something that was published in the same publications that we rely on to show Guatemala's constructive knowledge in this case. And then you have in ICSID, and ICSID, of course, is where they are challenging Dr. Alexandrov. And they argue, and this is Spain. So when did Spain obtain knowledge according to them? They say it is only in July of 2017 as a consequence of a challenge filed in an unrelated arbitration involving Pakistan. So that shows that the challenge against Dr. Alexandrov in the TCC case was reported in GAR, in IA Reporter, and that gave Spain knowledge that these challenges were being made. Now, again, I believe it's even a separate question as to whether that is a new fact that from the date when you would measure, because it's not the underlying fact, which is the relationship, which was known and in the public domain many years before that. But even if you want to take the proposition that you are entitled to disregard publicly available facts that you knew or should have known of that allegedly give rise to justifiable doubts a manifest lack of independence or impartiality, until someone else comes up with an argument that they do. I mean, that's what they're saying here. But even then, as soon as someone else came up with that argument, in this case, Pakistan, it was reported. And you can see here that the references that they're citing are to, again, GAR articles, IA Reporter articles. And then when Pakistan challenges Dr. Alexandrov for the second time, And they raise the new fact, and this is a new fact in this particular circumstance. What they were relying on was that he had resigned in the Soles versus Spain arbitration as a result of a challenge based on similar circumstances, and were arguing that that was relevant, that that was indicative of his lack of independence and impartiality. And they brought that, again, they said their knowledge was triggered by the GAR articles, and those were published in, very shortly after those challenges were made. So these are widely reported. States, respondent states, and investor state arbitrations follow this, and then they react in accordance to it. So even if you took the challenges, when should Guatemala be deemed to have known about them? Well, when they were widely reported, and we have all of those dates, in the record, and we can compile them for you. We have on, a slide, all of those. And we also, of course, that deals with the earlier things. Yeah. As I said before, this is on the premise that we're talking about your question in particular. When did they have knowledge of these particular challenges and not of the underlying facts, which we've also addressed separately?
Thank you. Your comment on this, Mr. Torterola.
Ok. Primero, quisiera decir que la pregunta dice dos cosas distintas.
Well, first of all, I'd like to point out that the question actually says two different things to what the annulment committee says it's saying. The first question, and maybe if I had a Spanish version of it, I could follow it more closely, because question 10, which question was it? Mr. Alexandro routinely faced challenges. When did Guatemala first come to know of this? Guatemala. And what we're talking about here, in this case, is what Guatemala could hypothetically have been appraised of. So the first question doesn't refer to deemed knowledge, but it refers to real knowledge. And that's the question, and that's what we had come today prepared to answer. So I just wanted to first off clarify that point. Then the second part of the question is what Ms. Menaker has just stated. And first off, that's not when Guatemala came to know of this. It has, in the first question, to do with what Guatemala came to know of or did not come to know of. And the claimants in their presentations, and Ms. Menaker said that that was discussed at the time as to whether these circumstances should have been or should not have been subject to disclosure within the legal community. So on the issue of deemed knowledge, and I'd like this to be on the record, and the possibility that Mr. Blackaby might have known, and we don't know what Mr. Blackaby knew or did not know, or how he judged that. So according to Ms. Menaker's words, possibly Mr. Blackaby considered that that was not a situation that needed to be divulged to Guatemala. But what I can say is that Guatemala did not become aware of it through Mr. Blackaby or Freshfields. So let's now...
That is in line with what they've already said and what is in the memorials. Because they said Guatemala only knew of this later.
Sí.
That they said.
Ok. Después vamos a hablar ahora de lo que nos acaban de presentar recién.
Okay, well, let's go on to what's just been said. And if we read what is said about the ICSID case, which was presented to the committee wrongly. What paragraph 50 actually says is that Spain, could we,
It's not my presentation.
Yeah,
It's your
that's what I'm
slide.
asking. TECO,
If you can
could
show
you
that
share
slide.
that again?
Si ustedes leen ese párrafo, ahí no dice
okay, so if you read that paragraph, nowhere does it say that Spain asked anybody, nor did they request information from the tribunal. In ICER, the same situation arises as we have before us. In this case, the award had been issued. Spain was unable to put forward a challenge because they hadn't been appraised of the information. And in ICER, contrary to what Ms. Manacas just said, and has read bits of it, that situation is exactly the same as the situation we had before us before. Spain was not aware until after the award had been handed down. So that, I'm sorry, I'm not following you, Mr. Torterola. Paragraph 50, you're saying that according to Spain, and this is Spain's allegation, the facts surrounding the close relationship between Dr. Alexandrov and Brattle only came to light after the award was rendered, and then it explained when that moment was. And it refers to the public reports of the relationships that came out in 2017. What I'm saying is that the claimants' counsel has just said that this information was requested by Spain, and that somehow or other, when it was requested as part of the proceeding, and when it was requested as part of the proceeding, we were told what could have been done by the parties to have access to that information, but didn't. But that's not what it says here in paragraph 50. And I'm not sure if I'm expressing myself clearly. Would you agree that Spain in paragraph 50, this is according to what the committee believes Spain is saying, that the facts surrounding the close relationship between Dr. Alexandrov and Brattle were facts that only came to light through the challenge that was put forward as a result of a case involving Pakistan in 2017. Do you agree that that's what the committee is saying with respect to Spain's opinion? But that's not what I'm referring to. What I'm referring to is that we're being told, and the slide title states that respondents states request information. Respondent states regularly rely on industry media. That's the title. And they asked the parties, Mr. Alexandrov, in the actual proceeding, requested information, or at least that's how I understood it, but perhaps I am mistaken. So I think the argument that's being put forward here is that when the states wanted to find or inform themselves of a given situation, they asked for that information. That's how I've understood it. And I believe that ICSID is in the same situation as we are in here. And Guatemala has been appraised of the information once the actual proceeding was over. And that's what I'm saying here in this case. And it's paragraph 50. I believe it doesn't correspond to what was said or what I understood to have been said. And parties or a party may find themselves in a situation where information comes to light once the situation or the proceeding is ended. And that's the situation that we're in here. And on this slide, you can see a number of references provided, and they are to information that are closed systems that you have to subscribe to. It's not publicly available information. The Attorney General's office doesn't have access to these subscription-based sources of information, and there's no evidence at all to say that the Attorney General's office is subscribed to the GAR or any other subscription-based source of information. Had that information been in the public domain, then that information would have been available. But if it's closed sources, then it wouldn't have been published in the media in Guatemala. And information was being requested here, but here we're being asked to disclose or to inform you of what we knew of and what we did not know of. And basically that is the basis of my comment. Thank you.
Just say that what you've just submitted is a good example of why, in my own view, the answers to the questions the tribunal has posed would best be dealt with in writing. For this reason, that you have sensibly, because you're speaking orally, gone back over a number of matters that are already within your existing submissions. And what we are looking for in the answers to the questions is a compilation of what has already been said and what is already in the record regarding these questions, so that there is not, so that we can pull together in one place from the submissions, from the oral presentations here, from the slides, where we can find the answers to these questions. And I think it demonstrates, at least for me, why there will be real value in each party putting together in a holistic way for us, rather than re-arguing what we've already heard, where we can find the answers to these questions. So thank you for that. It just enabled me to clarify in my own mind how best I will be helped by the answers to the questions in writing.
Perfecto. Yo estaba simplemente, le agradezco mucho. Yo simplemente estaba respondiendo lo que la señora.
Yes, thank you very much. I was just answering the comments or responding to the comments made by Ms. Maneker. And if I've repeated myself, then I apologize.
No. I'm not criticizing you for repeating what you've already said. It's a natural consequence of the exchange that occurred. Thank you.
Gracias, Professor Jones.
Thank you very much, Professor Jones.
Actually, the cases have been suggested by the claimant side. Talks about the relationship between Alexandrov and Brattle, which is the case, given the date of the case that is in the public domain, relating between the Kosmazek and Mr. Alexandrov, where he was challenged. Can you give me the date for that one? You know what I mean? This because the relationship is different.
Sí, son,
So when did that come to the public domain? Public domain, not actual knowledge.
That is TCC. It's the square, right? The September, October. Is that it?
No,
Or what is it?
no. In TCC, if you recall, I had a slide from the opening showing that these challenges are made against Dr. Alexandrov with respect to numerous experts, right? So this is the challenge, or so-called challenge, where they're challenging his relationship with Mr. Alexandrov. Now, excuse me, Mr. Kazmarek. Now, you cannot say that again, and this is why we have to look at the underlying facts and circumstances, which is the relationship with